great pleasure to welcome you all to our Spring 2024 Duke Law Faculty Author Talk Series. I would like to begin by thanking the Dean's Office for sponsoring the lunch, our colleagues in IT and Media Services, and my wonderful partners at Goodson Law Library, Jennifer Behrens and Shauna Bangarol, for making this all possible. Today, we'll be celebrating Professor Neil Siegel's newly published book, The Collective Action Constitution, by Oxford University Press. And I can tell you this book is truly hot off the press because I don't even have a physical copy to show you the beautiful cover at the moment. However, I can guarantee you that you'll see the copy in about 2 weeks in multiple locations in this building, and you will be able to access online as well. Today, we're so honored to have Professor Jeff Paul to moderate this conversation for us. Professor Paul is a renowned constitutional law scholar and a prolific author. His book, The Practice of American Constitutional Law, as many of you may remember, was featured in our Spring 2023 Faculty Book Author Talk Series. What is even more exciting to share, and it's totally irrelevant today, is that he just had a new book called The Foundations of American Law, a companion to the One Now Year, specifically written for many of you who are taking common law classes or who are just interested to know more about how lawyers and judges think, was just published by the Carolina Academic Press about a month ago. And so we now have the foundations, we have the practice, and now it's a perfect timing for us to look at the Constitution again from the collective action principle perspective. So now, without further ado, please join me in welcoming Professor Jeff Paul and our author speaker, Professor Neil Siegel.
Thank you so much, Alex. And welcome to everybody. Thank you for being here. I'm honored and excited to be part of this celebration. Just a word or two about the author whom we're celebrating. Neil is, of course, the David W. Eichel Distinguished Professor of Law and Professor of Political Science at Duke University. He's the Associate Dean for Intellectual Life. He's the Director of the Summer Institute on Law and Policy. He's had numerous positions. In addition to his academic work, he's been special counsel in, I think, to a senator in 5 different nominations, or is it 6? He has also clerked for Justice Ruth Bader Ginsburg, who is the dedicatee of the book. He was a Bristow Fellow in the Office of the Solicitor General, and he's a prolific author and a dedicated teacher. Let me tell you a promise I made to Neil at his request. The request was that I say nothing I don't actually think. Don't engage in puffery or, exaggeration or whatever, and I'm not going to. So everything I say, critical or laudatory, is what I actually think about this book, the Collective Action Constitution. I'm not going to try to describe the book. Neil and I plan, after I say a few more words, to just have a conversation about it. So I'm going to leave it up to him to really describe the book. As the title suggests, the book is an attempt to describe the Constitution as a whole using the tools of political science and game theory. The Constitution, he says at one point early on, has as part of its structural DNA the creation of Congress's authority to solve collection action problems for the states, and the state's general lack of power to undermine those solutions or cause such problems. And the rest of the 500-page book then proceeds to lay out that account, explain how it applies, and address problems and significant issues in today's world. By the way, let me just say something that Judge Richard Posner once said about an opinion by Justice Ginsburg. Posner said that I don't often wish the Supreme Court opinions were longer, but this one is different. I actually agree about that particular opinion. You can ask me afterwards which opinion it was in which case. But you know what? That's true about this very long book. I would have liked it to be longer. And that is the first true thing I'm going to tell you about, specifically about the book. Let me just tell you the 3 parts. Part 1 is foundations, and there are 2 chapters in that part. And what they do is, there's a beautiful description of McCulloch against Maryland. the best description I have read in short compass of that seminal and foundational decision. And then the second chapter is a description of the theories and game theory ideas about collective action, so that you understand the political science and game theory concepts that Neil is going to be using. Now you might think, well, he's got the one thing, he's got the other thing. What works about part one is the two things, he connects them successfully, persuasively, so that you see the way that the collective action, modern game theory thinking, is both presaged by and serves to help explain and understand the kind of things that Marshall and his colleagues were saying in 1819 and thereabouts. Then in part two, Neil gives a remarkably comprehensive discussion of the way that his theory explains much of the Constitution, enables us to understand it, and illuminates even those aspects of the Constitution that he readily concedes are not themselves primarily understandable in collective action terms. And then in part three, he tackles some vital, big-ticket issues about, does this work nowadays? How far does the collective action Constitution that he's described, that he thinks that the founders created and developed over time after that in various ways, to what extent does that permit the solution of the problems it was designed to solve, and to what extent have either flaws in the system itself or problems in today's world, to what extent do they balk the attempt of the Constitution to solve collection action problems? A couple of other descriptive comments. One thing that's notable about the book is that again and again, Neil explains how you can make use of what he's saying without agreeing with him. You don't have to buy the value of the game theory foundation, that part one of the book, in order to make use of what he says in the way he says it. You don't have to agree with his particular normative commitments. And although this is a theory that Neil has written to be accessible to and usable by people who don't share his normative commitments, it's nonetheless one in which you can see his, but he persuasively shows you how this can still speak to you, even though you say, well, in the end, Neil, I don't buy that. And there's one big ticket issue on which I may not buy what you say, Neil, and I'll tell you about that in a bit. The other thing that is striking about the book is Neil does not purport to provide a theory that ensures morally or politically desirable outcomes. In fact, he illustrates, in particular reference at one point, to the Fugitive Slave Clause in the famous or infamous case of Prigg against Pennsylvania, illustrates the way that collective action thinking can enable the government to do bad things, very bad things. So it's a theory that is grounded in the real world and doesn't purport to do more than, in fact, any theory could possibly do. Well, all that for description. Let me say a couple of things about how I think the book succeeds with respect to a concern that Neil addresses up front and repeatedly. Aren't you really, in the end, just doing political theory or something like that? Haven't you lost your connection to constitutional law? Why should a lawyer care what you're doing? I think he succeeds in saying that, no, that's a misguided critique. As he says, the critique that this idea is social science, not constitutional law, is historically inaccurate and generally misguided. He gives a beautiful, all too short description of the history of conscious collective action thinking about the Constitution. But the more general point he's making, and he quotes the famous line at one point in a specific context, was made in general by Justice Frankfurter in his Youngstown opinion, the Still Seizure case. It is an inadmissibly narrow conception of American constitutional law to confine it to the words of the Constitution and to disregard, and then Frankfurter talks about disregard the gloss that history has put on the Constitution's words, but Neil would say, I think correctly and persuasively, that to disregard the other aspects of the Constitution and constitutional law that are not narrowly and professionally legal. And I think the book works. The other thing I want to mention in this context is that Neil is, as I said, not concealing his own normative commitments. He notes the way that that's not a bug or a fault of his or something. That's unavoidable and always to be found. He says, for example, at one point, speaking of Chief Justice Marshall, Marshall's own normative commitments partially inform his interpretation of the Constitution. the Constitution and constitutional law are made by and for human beings, and human beings have particular perspectives and particular normative commitments. And to quote Holmes, the Constitution is made for people of fundamentally differing ideas. And to quote Marshall, the judgment is so much influenced by the wishes, the affections, and the general theories by whom something is to be decided that a contrariety of opinion on a particular question should not be surprising. We're going to disagree. And this is a book about understanding the context, the constitutional context in which we disagree, the ways in which it can help us disagree constructively, and the ways in which it can't. One other observation about this, and then I'll turn to a different matter. The book is full of specific observations that are just fascinating, worth the read just to come across them. I'll give you just one example, so I don't take up much more time. On page 98, Neil addresses succinctly one of the besetting sins of constitutional lawyers and judges, which is the attempt to answer constitutional questions by pseudo-historical assertions. So, for example, you solve some issue about federalism by saying that, well, the states created the Constitution, and therefore something follows. Or the Constitution is a compact among the several states. Or the other way around, the nation created the states, and the Constitution is the act of the non-state divided American people. Well, those are, when they're used as supposedly historical assertions, they are not historical at all. They are normative assertions that are being used to advance the ball without conceding that that's what they're doing. And Neil displays how that's so in about half a page. It's taken me longer to describe it than it took him to actually write it. This is constitutional law written for grown-ups. This is constitutional law written so that people who are able to live with disagreement, able to listen to others with whom they don't start out agreeing, can learn something and can engage further in the discussion. And one thing the book does more than once is invite the reader to go to, work from here to somewhere else, to wherever else the reader is interested in going. And the book is a wonderful success in that. So let me not close because I want to make my criticism now. What are the characteristics of the book that lead me to commend it to you with utter enthusiasm? Let me start with the writing. I've read drafts of some parts of this book more than once, and at least in one part of it, earlier versions of it from a long time ago. Neil has worked at this until the book is a joy to read. I quoted Posner, and I wasn't being facetious. The book is long. I don't have a copy either, except I've got a PDF printed out. But when I have the copy, someday I'm going to reread it, and I'm going to reread it with pleasure because it's that kind of book. It is uncluttered. It is clear. It has the simplicity of mastery, of actually understanding what you're doing and being able to state it well and clearly. It's not cluttered up with endless footnotes. There are plenty of footnotes, but it's not cluttered up with unnecessary ones. It discusses lots of cases, but it's not cluttered up with multiple citations and parentheticals explaining cases, blah, 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 blah. All the stuff that we usually do. So the writing. Read it for the writing. Read it for the story of the Constitution it tells. This is the most successful use of the Articles of Confederation as an essential backdrop to understanding the Constitution that I've ever read. Neil continually recurs to the Articles and the way in which the Constitution was designed to solve problems the Articles had permitted or encouraged. He also makes repeated use of the Federalist Papers, of the debates in Philadelphia, of early debates. Early on, Neil says, and it's true so far as it goes, that he's not an originalist, although he's making use of original understanding, and for that matter, original intent and original meaning arguments. But I think there's a way, Neil, in which this is an originalist book. And here's the sense. It's the originalism of purpose. The originalism of, what was meant to be accomplished by the Constitution? And that is central to what the story Neil tells. And the story I learned a tremendous amount, and it is worth reading just for that. And then finally, and then I'm going to say my criticisms and sit down. This is an incredibly ambitious book. The book that I think of, and I've read, as I say, much of this book more than once, is this last reading. The book that I kept thinking of, as I read this one, was John Hart Ely's Democracy and Distrust. Democracy and Distrust is beautifully written. It presents an idea that is, in fact, very complex and can be applied in all kinds of ways, but it does so with the utmost simplicity, clarity. You can walk away from it. I read it when I was in law school, and I was going, oh my gosh, this is astonishing. And I could have given you a reasonably accurate idea about the basic notion in the book. Now, Neil may suffer the same fate that Ely did, which is to have everybody then bashing. That happened to Ely, but that's okay. And Neil will think it's okay because that's part of what he's committed to, argument and discourse about the Constitution. So this is an incredibly ambitious book. And it's a book that, in that ambition, achieves something that I really tremendously admire. Well, one of the many things I admire, but the one I want to leave you with is it's inspiring. And Neil himself at the very end, this is page 485, says that the main point of empowering the Constitution or Congress to solve collection action problems for the states is more inspiring than mere efficiency. It is the search to create a more integrated union, both politically and economically, to make a more perfect union as a moral goal. And this book argues that case for the Constitution with great power. Now, Neil, every word I've just said is, in my opinion, true. But let me tell you what's wrong.
Thank you so much for your comments. The seat is just awaiting.
There are two things wrong.
Yeah.
One is, I don't know that I'm convinced by the way you use the states. The states, and I think this may be necessary to make the whole thing work, the states are treated as actors who can think and like and dislike and so on. And that is a hard swallow for me because one commitment of mine is that talking about states or federalism, or for that matter, national supremacy, as abstractions is kind of a mistake. And there's that beautiful postscript on methodology in which you attempt to address this, but I don't know that I'm yet persuaded. And that's pretty foundational. But even if I'm not, you've already told me I can learn a lot. The other defect or problem is the one you've already identified in the book on page 20. The Constitution's greatest defect, you say, in modern times is probably that Congress can't play the role that the collective action Constitution requires it to play. It's no longer capable of doing that. There were problems built in with it doing that, but they've gone through the ceiling. Maybe what we've got left with is something where power is going to flow to the executive with all the problems that represents, or to the courts with all the problems that represents. In which case, well, in this case, this book, and this is my fear, may be an elegy rather than a description of the future. But Neil, if that's right, and it won't be your fault if it is, if that's right, then I want to quote you some words that I think apply to your book and prove its worthwhileness, even if it turns out that your somewhat hopeful perspective is right and we manage to overcome our current problems. Someone wrote a long time ago, in a somewhat similar situation, that the reason he had written the book he's introducing was, though for no other cause than this, that posterity may know that we have not loosely through silence permitted things to pass away as in a dream. You've written a book that tells us powerfully what the dream of American constitutionalism has been, and if it fails, at least you will have written something that is noble of it and that others can know. Well, they didn't just sit there and watch it disappear. They spoke for it. And that's what I had to say. Truthfully.
the older I get, the more mindful I am of the moments in life, and there are not a lot of them, but they come, and you could miss them if you don't pay attention or you're distracted. But those moments for gratitude, to feel grateful, and not just to say you feel grateful, but to actually feel grateful, and to not want more or wish for more. That's a moment I feel now. The greatest compliment I received, and by the way, after today, let's be real, this book is either going to be ignored or criticized, and I'm hoping for criticized. But the greatest compliment I received before today was this book was 500 pages of ambitious centrism. And I think there's a lot of truth to that. And the greatest compliment I received now is that this is constitutional law for grown-ups. And I intend it that way. And my inspiration for writing this book, the person who pushed me the most, my role model, the person if I think of who of my colleagues and dear friends is truly learned in the law, it's Jeff Powell. He has been a model for me in many ways about how to do constitutional law for grown-ups, right? And it's important for us as scholars and guardians of the Constitution, for our students to see examples of this. We live in times in which it's very easy to just be cynical, to just be nihilistic, to just think it's all about politics, it's all ideological, right? There's no there. That's not how Jeff writes and thinks and teaches about constitutional law, and it's not how I aspire to do it, even if I sometimes fall short. This book has been a very humbling experience for me. When Jeff and some others were pushing me to do it, it just seemed overwhelming. I've been thinking about this subject for at least 15 years. When I thought about I wrote lots of articles and essays, especially pre-tenure, to overwhelm my colleagues with quantity, and I still wasn't writing nearly as much as some contemporaries at other schools. But I was left with this nagging feeling that I'm not really sure I really knew anything, or really knew what I was talking about. And this was an opportunity. If I was going to do it, I was going to do it right. And I started doing it before the pandemic. It was my playmate, kept me company during the pandemic, and Jeff said, write on a broader canvas. And that's what I spent the last 5 years or so doing, integrating, deepening, extending into new territory. My thinking about the constitutional structure, especially the federal constitutional structure, really since I began teaching. And it's also left me with a much greater appreciation for entities and ideas and approaches to constitutional interpretation that I may not ultimately be associated with, right? There is a lot of originalist argumentation in this book. And its original purpose, it's also original intent and meaning and understanding. I'm not ultimately an originalist because I wouldn't be commending the collective action constitution if I thought these structural ideas at the founding turned out to be disastrous for the country. But I don't think that's true traditionally or today. I think it's too hard to be just an originalist, which is why, none of our justices is just an originalist. But it's very important, it seems to me, to take a lot of originalist thinking seriously. Ditto the states. I began and ended up a nationalist in the sense of believing in robust federal power, but also not limitless federal power, not just in principle, but in practice. And states are the basic units of constitutional analysis in my theory. They play vital roles in the constitutional system. We could not do without them, just like I don't think we could do without the federal government. I cite my colleague Ernie Young a lot in this book, and it's not just or even primarily but C, right? It's agreement with a lot of his writing about federalism. And so if you're going to do con law, right, as a grown-up, and it's not just going to be a way to vindicate your own ideological commitments, if you're going to try and talk to people who don't necessarily agree with you about everything, it seems to me really important to take their own normative commitments or premises seriously, their own approaches to interpretation. And I try to do that in my writing, and I try to do that in my teaching and speaking and debating about the Constitution. The basic claim of the book is why does the constitutional structure matter? Why does the federal structure matter? Why do we have a constitutional convention? I mean, one often hears the answer is because we need to constrain federal power to protect the states and protect individual liberty from federal overreach. Now, there's definitely something to that. We do need to protect state regulatory autonomy. They do jobs that the federal government can't do well. It is important to protect individual liberty and dignity, not just through rights, although I end up endorsing vigorous rights protections as a trump on collective action thinking in light of historical abuses like enforcement of the Fugitive Slave Clause. That's all true, but there's something profoundly incomplete and ahistorical about that claim. I mean, a great way to limit federal power to protect the states and individual liberty is to not have a federal government, or to have a really weak and ineffective one. And we tried that. It was called the Articles of Confederation, which was actually a major accomplishment as a way station towards a more effective, functional national government. It created the states and the United States as legal categories. But there were serious problems under the Articles of Confederation. The problem is we didn't have a federal government that could solve basic, fundamental, existential collective action problems, like funding the national government, like protecting the states from commercial and military warfare waged by foreign powers, superpowers. We were a young, vulnerable nation. There was no power to protect the states from commercial warfare and other troubling behavior from sister states that could very well have turned violent and in some cases did. The Constitution is created primarily to solve those and other collective action problems facing the states, situations in which all or most states would be better off if they could cooperate or coordinate their behavior. But there are a variety of different impediments to their doing so. And it's not just the Commerce Clause that's illuminated by this idea. It's not just Article 1, Section 8, where most of Congress's powers are housed. It's various limits on state power in Article 1, Section 10. It's the basic purposes. I mean, Articles 2 and 3, right? They didn't exist under the Articles. If you want to actually enforce federal solutions to collective action problems, you need a government with arms and legs. You need an executive branch and a judicial branch that can enforce federal law, as well as deal with foreign policy problems, protect the nation from attack, resolve interstate conflicts peacefully, protect people from out-of-state bias, state parochialism. You go down the articles, Article 4, interstate relations, all the ways in which states are not allowed to do things or Congress is implicitly or explicitly allowed to do things. So many collective action justify what's going on in Article 4. Article 5, the amendment process, I have some real criticisms. I think it overrepresents the states. It's not hard to explain why this Constitution is so extraordinarily difficult to amend. Article 6 and supremacy principles follow straightforwardly from a collective action account of the Constitution. Article 7, who even thinks about that today, right? Where the Constitution self-declares what it's going to be required to ratify the Constitution. Well, they learned from the Articles. It wasn't going to be unanimity. It was going to be 2/3, right? 9 states were going to be necessary to ratify the Articles. We're going to avoid the holdout problem. Rhode Island wouldn't even showed up for the Constitutional Convention. So lots of different parts of the Constitution are either partially or significantly illuminated by this theory of mine, and parts of it aren't. The states play very important roles, and preserving their regulatory authority is an important part of the Constitution. Collective action thinking can explain some constitutional rights. They have structural collective action dimensions that I could list for you. But the primary role of the Constitution in protecting individual rights and the primary role of Congress in passing civil rights legislation, any collective action rationale is going to be secondary. I call that the Reconstruction Constitution, not the collective action Constitution. That's how states relate to their own inhabitants. That's different from how states relate to one another or how states relate to the federal government. The Constitution is too important, too complex, too ultimately mysterious for any one theory to explain it all. And any theory that purports to explain it all is probably not explaining very much. And I think the limits of the theory are just as important as the promise, because I think they help define and sharpen the idea of collective action, where it does apply, as well as explain why it's incomplete. Part of what it means to do con law for grown-ups is to not claim that you have a unified field theory of the Constitution, and to see that it needs to be supplemented with other theories and other considerations. And if I could just say, ending for now where I began, with gratitude. I mean, I take your criticism seriously, and I have responses, but I don't think this is the occasion to litigate the matter, although I'm happy to talk about them if people are interested. I think those are very good criticisms, and I take them very seriously. I'm just thinking about, I've talked about Jeff and Jeff's role. I mean, I've been blessed with 3 deans in my time at Duke Law School, and 2 of them are here today. Kate Bartlett is here, and she was my first dean. She's I was debating between Duke and Berkeley when I was on the market, but those are my 2 schools, and I just felt like I couldn't say no to her.
A lot of us said that.
That's there are advantages to not being married, not just advantages to being married. I've seen both sides of that. David Levy was just 11 years of a blessing. And most recently, Kerry Abrams. I mean, I take my institutional responsibilities very seriously. I take my teaching responsibilities very seriously. And she took my scholarly aspirations very seriously. This book would not be done now if she hadn't done that, if she hadn't said, Neil, your book is more important. We have other people who can do certain things, right? Finish your book. And a dean has a lot of power to make a faculty member's life better or worse. And, my deans have always made my life better and, the lives of my colleagues better. And I'm really, really grateful for that. And deans are often, I don't know, it's a thankless job in a lot of ways, it seems to me. And people are always complaining and telling them what they want and what they're doing wrong. But I really see very clearly the deans that I've had. My colleagues have read parts or all of this book. They're in the acknowledgments. I can't list them all here, but I do want to mention, if it's, and please, for people I don't mention, don't feel offended. I'm grateful to all of you. You're in the acknowledgments, but my former colleague and dear friend, Guy Charles, who moved to an equally ranked school named Harvard, all that energy to just stay ranked 4th. I never aspired to be at a school that was ranked higher than the basketball team, but so be it. He held a book workshop for me at Harvard, where he is now, and Matt Adler came. And Matt is one of those few people in public law who knows the economics and the formal theory as well as he knows the constitutional law. And Matt really got this to the finish line by pushing me to be analytically completely precise about the different categories of collective action problems and what distinguished them. And the need I had for a third category, and I'm really, really grateful to Matt, who was so generous with his mind and his time. He came to this, traveled all the way, to the Duke of the North to help me make the book better. And again, this room is full of people who've read parts of the book, and I'm grateful to them as well. I don't know if I guess we're not out of time yet, but turns out I had a lot more to say initially than I expected.
Well, Neil, why don't we want to open it up to questions and answers, but let me start with pushing you again on my question.
Sure.
Tell us some more about why you think the states work as primary analytical units.
Yeah. So, I mean, there are different ways, right, to think about or model federal power as a matter of, we could think of individuals, right, as the players in the various games that face collective action problems, and states as intermediaries, and then the federal government as the government of the group as a whole, right? I think of the states as the entities or units that are facing collective action problems, and the primary role for the federal government is to intervene when the states, right, are unable to solve problems effectively on their own. I don't think the two approaches have significantly different implications for the scope of federal power. I do think they have different implications for constitutional design and the legitimacy of the regime. I take the design and the regime, the hardwired parts that are not going to change, as givens. The equal representation of states in the Senate, which can't be changed even through an Article 5 amendment. You would need the unanimous consent of each state, right, to change that. And so I view the American people as the ultimate principals, and their agents as being either the state governments or the government of the nation as a whole, the federal government, where the states collectively go to solve their collective action problems. And I think the primary reason I do that is I think it makes sense of some basic features of our regime, which is the equal representation of states in the Senate, the fact that we are in part it seems to me that we're some kind of combination or compromise between we the people and we the state peoples, not we the state governments. The state governments didn't ratify the Constitution, but we the people and we the state peoples. And by using the states as opposed to the individuals as the units of analysis, I'm able to justify robust but not limitless federal power based on grounds or assumptions that don't demand a strong prior normative preference for nationalism. And I think that's no small thing in the world in which we're living today, because the greatest threats to the system as its long function come from those on and off the courts who want to significantly shrink federal power. And what I'm showing is that you can start with the states as the basic unit of analysis and still justify robust but not limitless federal power. You don't need to start with individuals and agree with Marshall's statement that we the people as a series of individuals ratified the Constitution. And Marshall himself didn't think much turned on whether we thought of it as we the people or we the states. And I think for the reasons I've explained, I think that's right. Now, another possible way of cashing out your criticism is we know that the states, right, states are a they, they're not an it. In fact, you don't need modern political science and economics to tell you that. You can just look at the constitutional text. Sometimes the text talks about state legislatures. Sometimes it talks about state executives. Sometimes it talks about state judges. Sometimes it talks about state electorates, right? The states are a they, not an it. And I think my simplification in talking about the states as the basic default regulators in the American constitutional system is a way of saying whichever governmental subunits of the state are empowered in the situation to make the decision, right? States are unitary actors in the sense of having a unitary decision to make, which is a simplification we often see in law and social science. The federal government is also a they, right? That simplification, I think I also mean whether the federal government as a whole or whichever subunits are empowered to make certain kinds of decisions. So it is a simplification, right, as any model is a simplification, but I think it can be cashed out more concretely in a context-sensitive way, that I'm not just talking about the states, I'm talking about state legislatures, or I'm talking about state executives, right, depending upon which portion of the constitutional text or which constitutional provisions we're talking about.
I wonder if, before we ask for other questions, let me just briefly follow up. I think you should say a word more about the Reconstruction Constitution and how it fits into this.
Right. Yeah. So if we ask, if we ask most Americans why do we have a constitution, I think the answer they would probably give today would be to protect rights, right? To protect our rights. And that was not the primary original purpose of the Constitution. The Bill of Rights limited the federal government. It was not a Bill of Rights in the modern sense. It was a Bill of Limits on federal power, because the anti-federalist objection was that this new Constitution was going to create too powerful a federal government. And the Bill of Rights was in part a response to that. It's not until an epic, savage civil war that kills 2% of the American population. Today that would be more than 6 million people, proportionally. And the Civil War amendments and the gradual incorporation of the rights protected in the Bill of Rights, just about all of them today, by the courts into the Due Process Clause of Section 1 of the 14th Amendment, and then the addition of more amendments that both protect individual rights through the courts and empower Congress through enforcement clauses to pass civil rights legislation, that we get the modern conception of the Constitution as an important part of protecting rights. I think the main way I think the collective action Constitution is incomplete is that, again, it can explain significantly the dormant commerce principle, the privileges and immunities clause, the right of people to travel and move, into and out of states, the full faith and credit clause. There are certain personal jurisdiction matters. There are individual rights with structural components that I think my theory can provide significant illumination of. But the primary role of the Constitution in protecting rights against government at all levels is what I call the Reconstruction Constitution. And again, it's what Madison presciently wanted, but was either misunderstood or ignored by his contemporaries at the time of the founding, and which required repudiating his own views on race and slavery in order to achieve. It's how the states relate to their own inhabitants. That's different from collective action problems facing the states, from how the states relate to one another or the federal government. And I think you need both parts, right, as well as certain key protections for state regulatory autonomy to have as well as certain functions that the separation of powers in the interrelation of powers plays to have a relatively complete account of our own Constitution.
I agree. Questions?
It's very gratifying to see not just my colleagues, but so many of my students here, and I'm very thankful for that. So please, I know some of my students are not at all bashful, so by all means, happy to hear from colleagues. Also happy to hear from students. Yes.
Sure. I've read your book. I'm very excited to read it.
Yeah.
Something we talked a lot about in our Fed courts class was about the state courts and the federal courts, and how at the founding they kind of consider the state courts like in parity with the federal courts. Mm-hmm. Does that come up in your book about like the role of the state courts in relation to the federal courts in this collective action?
Yes, and thank you, Joanna. Joanna is my go-to person whenever I have a common law trivia question in federal courts, because she always knows the answer. I mean, I even asked how many times how many times Justice Kennedy cites Marbury in City of Bertie, right, where the court says, "Don't question my authority," and she knew the answer was 4 times.
Professor Powell was my comma professor.
Well, okay. We've talked about you calling me sir before and how it makes me feel. But it all makes sense to me now. So, I mean, Chapter 7 has a whole part on Article 3, and I think Article 3 is in very important part explicable in federalism terms. When we think about the basic purposes of federal power, it's enforcing federal law. It's deciding disputes with international dimensions that raise foreign policy or national security concerns. It's peacefully resolving interstate disputes, including when attempts to form interstate compacts fail. It's having a federal forum for cases of potential bias against out-of-staters, right? When you think about the various heads of diversity jurisdiction. And I think there are collective action logics that animate all of those 4 basic purposes of federal judicial power, which are ways of understanding the 9 heads of federal jurisdiction in Article 3, Section 2. In terms of federal courts and state courts specifically, as we learned about, the Madisonian Compromise in Article 3, Section 1 basically kicks the can down the road with respect to whether there will be lower federal courts. The Constitution requires 1 Supreme Court, and then there were disagreements among the delegates at the Constitutional Convention respecting lower federal courts. And what the Madisonian Compromise says is that Congress will have the power to determine whether we need lower federal courts. Now, it's called the Madisonian Compromise, even though he was not the only delegate to suggest it, and he was not the first one to suggest it. I think it's called the Madisonian Compromise because he gave the best structural justification for it, which is potential bias against out-of-staters by state judges, which could lead to what in collective action terms we would call retaliation and a race to the bottom. If North Carolina judges are going to favor North Carolina litigants over South Carolina litigants, we can expect South Carolina judges to respond the same way, right? That was the concern. What the Madisonian Compromise says is that this is a potential concern. How much of a concern it's going to be going forward, right, is uncertain. We can't predict the future. So leave it to Congress, the institution the Constitution primarily empowers to solve collective action problems and prevent states from causing them, to make those situation-specific judgments as our time together unfolds in response to the various crises of human affairs, as Marshall puts it in McCulloch. And so the Madisonian Compromise, it seems to me, in a way that is not at all obvious if you don't think about the Constitution in the way I commend, right, is connected to the Interstate Commerce Clause, the requirement that interstate compacts need congressional approval, all the interstate relations stuff in Article 4, the congressional approval exception to the dormant commerce principle. Like, what does this stuff have to do with one another? It turns out a lot. There's a deep structural logic. Again, it doesn't explain everything. Each of these different clauses and principles have their own histories, their own language. It matters. Other considerations need to be brought to bear. But this basic idea of letting Congress decide whether the states are being biased against out-of-staters, and we need federal courts as more neutral forum, right? Seems to me to be at least a good part of what's going on and what Madison said in favor of the compromise. Yeah. Great question.
Yeah.
Neil, congratulations.
Thank you, Darren.
A really great book, and thanks for sharing an early draft with me. So my question, I think, has to do with technology and the collective action constitution, because in some ways it feels like the more touch points there are between different states or people between different states, you almost ineluctably lead to more and more sort of collective action coordination problems, so that, you know, what a constitution that was where the the coordination problems were pretty apparent. What are we going to do with ports? What are we going to do with who owns, part of a river or something like that, are now multifarious. Because, a bank fraud occurring in one state is affecting an entire, monetary system nationwide. Or, think about climate change. The burning of fossil fuels in one state is having an effect throughout the state. So how do you think about the role of technology, and does it inevitably lead to more centralization because they all raise all these collective actions?
Right. So Darrell Miller is one of my extraordinarily generous colleagues and friends who read the whole manuscript and gave me great feedback when he's got plenty of his own work to do. I mean, it's technology. It's also the 20th century, right? It's a more integrated economy and society. And one way of cashing out the question is, doesn't that effectively result in unlimited federal power on a collective action theory? Because the cooperation problems, the coordination problems, the cost externalizations by individual states that are greater than the benefits those states themselves internalize, that just keep multiplying and multiplying. And I think there's something to the idea, something important to the idea that, again, a constitution intended to endure for ages to come and to be adapted to various crises of human affairs. As our society becomes more integrated technologically, economically, there's a greater role for the federal government than there used to be. I don't think that's something to be embarrassed about. It underscores the need for effective federal power and the concerns I have about courts that are substantially more aggressive, talk about originalism, than the framers and the founders wanted the federal courts to be vis-a-vis the federal government. Now, I don't end up where I think some of the most liberal nationalist justices end up. One of them once said something to me personally in private. It was not Justice Ginsburg, if you're guessing, that this justice would never put in an opinion, which is, we live in a modern society, everything's connected to everything, there's no way to draw rational, reasonable lines. It's basically, the safeguards of federalism are political, leave it to the political process, right? Because I still think, in principle, there are some judicially enforceable limits on federal power, and I endorse a number of them in the book. Even on my robust collective action understanding, the Interstate Commerce Clause is not limitless. The Taxing Clause is not limitless. The Necessary and Proper Clause is not limitless. I don't endorse the court's version of the anti-commandeering doctrine, but I do endorse a toned-down, modified version of the anti-commandeering doctrine. And I can give, examples under each of those clauses and principles where I think Congress could and has gone too far. For example, I think U.S. against Lopez is correctly decided, the 1995 decision in which the court, for the first time since 1937, invalidated federal laws beyond the scope of federal commerce power. I don't see what the cooperation problem is, or coordination problem is, or cost externalization that exceeds internalized benefits is regarding gun regulation in school zones. That seems to me to be an issue that the states are perfectly competent to regulate on their own. In contrast to, say, suppressing an interstate market for firearms, or dealing with the problem of individuals moving across state lines, going to a gun show, buying very powerful weapons without any kind of background check or regulation at all, then bringing it back to their home states and opening fire. Right? That, to me, is not just a problem for the state where they open fire. That's a problem for the union. Right? That's a problem that the federal government, because of the interstate nature and scope of the problem, should have something to say about. But I'm very comfortable with the conclusion that Lopez is rightly decided, and that Some of the commandeering cases as well are rightly decided. Congress, it's especially coercive, and Congress doesn't have unlimited authority, in my structural view, to simply use the states to regulate on its behalf. Now, at the end of the day, I'm still endorsing robust federal power, but it is not true that there are no limits at all that politics could enforce or that courts could enforce.
Yes. You. What are you?
Thank you both. This has been so interesting. You started, Professor Powell, by analogizing the book to John Hart's Democracy in Distrust. And I would be curious what thoughts the collective action Constitution has for systems of democracy and the law of democracy. And we're in a time when there is, I don't think the original Constitution was very little democratic. I'm thinking of like electoral college, and your analogy to the methods and thinking about the legislature does this function reminded me of the independent state legislature theory. So how do we think about your theory related to the Constitution and specifically issues of building this democracy with this instrument that maybe didn't conceive of itself as doing that initially?
Yeah, so I mean, it's a wonderful question, and I thank you for it. The original Constitution is not small d democratic by anything resembling what I would regard as minimally acceptable standards today, but it was astonishingly democratic by world historical standards at the time. And as Justice Ginsburg liked to say, it also had growth potential. So I don't think that should be lost sight of, right? It's the future is going to judge us just like we judge the past, right? But nonetheless, I hear you. The way I think about these matters in my book is the reason why I think Congress is the institution. Why is Article 1 come first, right? Why Congress is the principal institution that's given authority to decide in the face of state disagreement whether there are multi-state collective action problems in need of solving and how to solve them. It doesn't mean Congress has unlimited discretion, but it does have substantial discretion, right, for the courts to play a modest role in cases like Lopez, in my view, in which I don't think one could make a responsible collective action argument without extending the time horizon decades into the future. And the explanation I give for that is because I think Congress, it's not just federal power to solve collective action problems, right? A king or a queen could do that very efficiently. It's doing it with sufficient democratic warrant, right? Congress is the most, in my view, democratically accountable or responsible branch, notwithstanding all the ways in which Congress, right, doesn't function in ways, if I were designing the system, I would want it to function. But relative to the presidency, and I know people disagree about that, I'm happy to explain why I view Congress differently from the presidency, and especially relative to the Article 3 courts. I think Congress has, and especially relative to a single state legislature, in which it can do things, why can't a part tax the whole? Because the whole is not represented in the part, right? That's McCulloch. The second part of McCulloch. It seems to me the institution with the greatest democratic legitimacy should be the institution that should be making these judgment calls when the states don't all agree. And that's a connection I see between, say, the Compacts Clause, which purports to require congressional approval, and the Commerce Clause, which I think empowers Congress much more than it empowers the courts to say no to Congress. And part of the concern I have in the times in which we're living is power tends to flow to where it can be exercised, and it's flowing from Congress to the presidency and the courts, and from Congress to individual states. I think there's a real, in terms of efficacy in solving problems, I think there are costs. I think in terms of democratic deficits, there are costs. I think in terms of potential for backsliding, and concerns about potential authoritarianism, there are real costs. I think Congress is supposed to play the central role in the system. The Constitution presupposes a reasonably well-functioning Congress, and I think because it has national legislative jurisdiction and because relative to the alternatives, I think it has the greatest democratic warrant to make decisions when people disagree.
Well, thank you. Thank you, Neil.